Good afternoon, everybody. This is Charles Rather from AmLaw Group. Question today we wanted to discuss is, can an applicant file for a green card while on an E2 visa? And we can discuss this in the context not only of an E2, but any non-immigrant visa. So the thing is, if you've got a non-immigrant visa, an E2, L1, H1B, O1, those are the main ones we generally work with. Of course, you have a right to file for a green card while you have one of these non-immigrant visas. The challenges sometimes arise if, depending on the timing of things, your current non-immigration visa is going to expire, or exactly what kind of non-immigrant visa you have, because that could affect things too. So what are we talking about? First of all, out of those four categories, L1, E2, H1B, and O1, two of them allow you to have immigrant intent. So it's really not a problem if the consulate ever finds out or immigration service that you filed for an immigrant petition, because that's totally fine. Those two options are the L1 and H1B. So again, L1, H1B allow you to have immigrant intent. So if you're in the process of getting a green card while you have those visas, shouldn't be any problems. If you've got an E2 or an O1, yeah, you could have some issues. So what issues are we talking about, or how could those come up? Well, generally, I would say the main time you really might even have those issues, and this is kind of a might, it's not a definite thing, is when you are trying to renew those visas. So O1 is generally issued for 3 years. E2 is generally issued for maybe 5, but as little as 90 days. Depends on the country. So Canadians, for example, most Western Europeans, who else? Armenians, they get an E2 visa for 5 years. Other countries get it for maybe 1 or 2 years, and some poor guys get the short end of the stick and they only get 90 days for the visa. But let's just assume you've got a visa for 5 years. Say you've had the E2 visa for 4.5 years, you're planning to go in soon to renew your E2. But you're also planning to maybe get a green card, maybe through an EB-5, maybe through a labor perm, and through an employer. So you got the process going for the immigrant visa. There's a question in the forms when you fill it out at the embassy about whether you've ever filed an immigrant visa. And it's I don't have the wording in front of me, but it's worded kind of a vague way, and I've talked to a lot of other attorney friends of mine, and some people think one way, some people think the other. Technically, I think it says, have you ever applied for an immigrant visa? Well, if you filed a petition with the Immigration Service, technically you haven't filed for a visa. You just filed a petition that would, if approved, give you the right to apply for a green card or an immigrant visa. So if you want to be like a tricky lawyer, sometimes you could answer, no, I haven't applied for an immigrant visa, even though you're in the process. Now, at the end of the day, the sad thing is, if the embassy wants to do a little digging around, they can quite easily figure that out or find out if you do have a petition pending in at the Immigration Service, USCIS. So probably the safe thing to do is to indicate that, in fact, you do have a pending, EB-5 at USCIS that's being reviewed or something. And if they find out that you do have some immigrant petition pending, that shows you're planning to immigrate, which isn't compatible with an E2 or an O1. So the problem can come up then when you're at the embassy, at the interview, that they might say, oh, well, we see that you're waiting approval for a green card application. And they're afraid then that you're going to stay in the U.S. once that application gets approved. So your best line of defense in this kind of situation is to say, I may be awaiting an approval for an immigrant petition, but in any case, once I get approved, I'm planning to come back to my home country, let's say it's Canada in this case, and go through the immigrant visa process at the embassy and get my immigrant visa that way. The biggest thing they're worried about, even though there's nothing illegal about it, is you come in on your E2, you get your green card application approved, and you stay in the US and adjust your status. That's what they're most afraid of. So if it does come up, you have to reassure them that you're going to come back to your home country and go through the visa processing that way. Now, obviously, the rules should be the same for everybody, but the reality is they generally aren't always. So if you're from a more economically advanced country, Canada, Western Europe, I'd say they tend to give you a little bit more slack and not, issue any kind of denials. If you're from a more developing country, maybe, countries in the former Soviet Union, maybe South America, maybe Africa, they're going to be a little bit more stringent and less likely to believe you on that. So again, there's really no easy way to get around this. The best way to get around it, from our experience, is you renew your non-immigrant visa, whether it's E2 or the O1, and then shortly thereafter you file the immigrant petition, so that depending on certain circumstances, the immigrant petition will get approved before your current visa E2 or O1 expires. And so you don't even have to go to the embassy and explain to them why, you have a pending immigrant petition and you're filing for a new or renewal of your E2 or something. So when possible, we try to work the timing out in that way. It's not always easy to do that or time things. So then sometimes we have to go to plan B, plan C, and come up with some other options. So we'd be happy to consult with you on this or any other matters to make your process from a non-immigrant visa to an immigrant visa as smooth and successful as possible. Look forward to hearing from you. Take care.